Everybody, welcome to our webinar from Farrar's building. Thank you very much for joining us. You can see me, I'm in a virtual court background. The joys of Zoom is that you can put your virtual background on, and I apologise now, but if I hadn't put it on, you'd see what's been happening at my home, homeschooling, for the last 6 weeks of lockdown. So this is far better. The intention of the talk today, it's really just a practical chat, as it were. I'm going to be looking at practical measures by which we can assist the court to avoid the dreaded adjournment of hearings, as we all want matters to progress. And James will be providing his views and some commentary on virtual JSMs and indeed on some settlement provisions which courts are making now for parties in attendance, particularly down in Bristol and the South Coast. So, without further ado, first of all, of course, we do all miss the courts. We haven't been there for a long time. At the end of this, I'll be awarding prizes of virtual pints if you can name these 3 particular courts we miss greatly not visiting. A reality check. None of us know when the courts are properly going to be functioning. We've all been limited in our movements. Court staff and of course judges themselves have been limited as well. We've had some changes announced on the weekend, but we still don't exactly know when normality, if it's going to return, if ever, and what form that's going to take. So we're probably in for a relatively long haul of uncertainty in relation to court hearings, virtual court hearings, and actual court hearings. But what we can all do, of course, we're entirely dependent on the judiciary and the views they take about hearings going ahead. It's ultimately a judicial discretion and one which courts will rarely interfere with. Judges may well need some persuasion on some occasions to have hearings, but the more parties can assist the court in making those hearings progress seamlessly, or as seamlessly as possible, the better. I think it's important to step back and look at particular problems faced by the civil courts predominantly. Obviously, the criminal courts have huge difficulties at the moment. The family courts seem to be functioning better because of electronic bundles, and also matters things like the tribunals and employment tribunals, because they're specifically focused on one particular area. It may well be that they're able to overcome problems more quickly than the civil jurisdiction. Civil case files, of course, all paper files. They're not electronic. Some of the court files you see emerging are extremely old, contain many different papers and forms, not always the best organized. But one of the problems with them being on paper and not electronic is many courts have had to physically close, and there'll be some paper files that are currently inaccessible. Many court staff will, of course, have been sent home, and they're not set up to work remotely at home, these individuals. Many of them don't have laptops, and there has to be provision of that. So that's a lot of delay has been due to that. And of course, there's illness as well to take in consideration. A very large number of judges have been sent home and currently are working from home remotely. Not all the time, but a vast majority of time as well. And of course, that will, to a certain extent, depend on what facilities they have had at home and how quickly they've been able to adjust to matters. Remote hearings do take longer. Logistically, and they're more tiring. Fewer can be heard. And there are still competing claims on the court's time. Possessions may have been adjourned, but family disputes certainly haven't gone away. And a lot of court time now will be focusing upon what they consider as important family disputes, domestic abuse, non-molestation orders, private law applications, and that's going to take up an awful lot of the court time, and that's just a reality on the civil side we have to face. Is there any cause for optimism? Well, matters are slowly moving forward. If you're particularly bored one day at home, you can always go on to the court serve on the web, and you can see what's happening in the courts around you. And just, I think, out of interest, I was looking this morning This is the listing for Central London County Court today. District Judge Fine, he has 3 matters, 10, 12 and 3. Application hearings, preliminary hearings. We've got DJ Revere as well, has got 2 matters at 10 and 11. Obviously Judge Worthington's got a slightly busier list. We've got infant settlement hearings. We've got a case management conference. We've got an injunction hearing, pre-action disclosure applications. And also a slightly busier list there as well on the 4th floor. And District Judge Lightman as well, 2 hearings, a CMC and a 1-hour application. And in my personal favourite county court at Birkenhead, we've got family hearings. We've got applications in the morning for District Judge Doyle. And I wouldn't want to be a deputy district judge at Birkenhead because from 10 o'clock, back-to-back disposals, and poor old DJ Golding also has back-to-back disposals. So there is cause for some degree of optimism. Matters are moving forward. Obviously not at the rate we'd all want, but there has been progress in the last few weeks. Of course, it's important for everyone to keep cases moving. The courts recognise this. There's going to be, when the current crisis ends or reduces in scope, of course, there's going to be a huge amount of outstanding issues and cases which will have to be heard. And so, of course, it's in the court's interest to progress matters that they can now, because they will only have to be dealt with in the future. Every little bit helps. So focusing upon interim applications and case management, how we can assist the court in making sure that these do take place and these aren't adjourned. First of all, and it's an obvious point, but remember the power of the consent order. We don't actually have to appear before court or have a formal listing for court to approve an order. That can be by consent under CPR 23.8, where the court has considerable powers to deal with applications on paper. Parties can agree by consent, and I think it's important, and you all obviously realise just how important it is that there is to be cooperation between the parties. Much can be agreed before hearings, and consent orders are certainly one way. But of course, the parties don't necessarily have to consent or agree a particular order. They can agree that the court itself can dispose of the application without a hearing, and that may be where it's a relatively straightforward matter, not too complicated, and a really decision is needed sooner rather than later. If that process is entered into, it doesn't mean that submissions can't be made, as I understand the rules. I don't see why parties can't agree to make short submissions on paper and provide it to the court, and then ask for the court to adjudicate without a hearing under CPR 23. Of course, one of the benefits of consent orders as well is they don't necessarily have to go before a judge for approval. And CPR 40.60 provides you useful indications as to what consent judgments can go to a court officer rather than going before a busy judge. If matters are to go before the court, anticipate the likely problems and objections raised by judges when suggesting that they can't hear a matter or not list a matter. Keep applications simple if possible. Keep time estimates sensible and realistic. And by that, time, what I mean is time has, of course, become even more important to the court. Although telephone hearings, one of the benefits of telephone or video hearings is that you're allotted a particular time, it does mean that there's additional pressure on the courts to keep to those time. It's not a simple case where they can send you out of court to wait. If time is becoming more important, a judge is more likely to want to adjourn a hearing if inadequate time has been allowed. So if applications have been made now, then obviously give a sensible estimate, not too short a period, just to get it in early, and a sensible estimate there. Very often when making orders, sometimes speculative aspects are tagged on to the order. For example, you may want to obtain an unless order against another party, but part of the application is you also make a primary case of strike out the claim, or in the alternative, an unless order, there may well be merit in limiting the applications to what is sensible and realistic. For example, in that case, an application seeking an unless order is going to take slightly less time, but also more capable of agreement perhaps with the other party. And if you can agree as much as possible with the other side before a hearing, and the judge is told that issues have been narrowed and the parties have worked together, he or she will be inevitably more grateful and less inclined to adjourn a hearing on that basis. So it's always of benefit to talk to the other side, or if you're instructing counsel, to give counsel at least some indication that the other counsel can be contacted and steps making to narrow the issue between the parties. Assume nothing. And by that, I mean, don't assume that the judge has all the case papers in front of him or her when your application might be being heard. The case files they have, they may not have been able to obtain them because they're in a court that's closed. There may be missing documents that simply have been lost or cannot be obtained because there are insufficient court staff to chase it up. That being the case, you can always provide documents to the court, email to the court. And there's, again, it seems to be that they can be and they should be before such a hearing. Assume that it's better to supply too much than too little. And I'd advise, provide all previous court orders, so there can't be a complaint by the court that they got insufficient information before them in relation to matters that preceded it. Provide relevant pleadings. If they're missing from the court file, at least it allows the judge to know what the main case is about. And of course, if you are going to provide these documents, make sure you copy the file to all participants as well. But certainly I don't see a problem with supplying the case papers for an application to the court. When you do send electronic bundles and documents, there'll obviously be directions from the court to do so. Some courts have imposed limitations as a number of pages. I know Central London does that. Others, there's a physical limitations to the size of particular files. There are personal judicial accounts are able to accept larger files, and it may well be that you have been provided with a particular judge's e-judiciary account. And if you're permitted to send direct files to that, it does allow larger files to be sent, it seems. The electronic bundle should be properly paginated. Sometimes if they are made from a printed bundle, so there might be a printed bundle provided as well as electronic bundle, the PDF can sometimes page numbering maybe a couple off the actual paper bundle. So it seems in that circumstance, make sure it's clear what pages are going to be referred to, and that the judge knows if there's a difference between the two. An obvious point, make sure there's an index. Nothing's worse than getting multiple attachments without knowing what they are and what's in the bundle. And if separate files are sent because files are too large, make sure each one is appropriately labeled. So when you're naming the particular file, it would be helpful to give it a name with the page number, start off with the page number, the bundle, and then a general description. So for example, pages 50 to 100 and the pleadings. That way the judge, if he's accessing the documents from his e-judiciary folder, will be able to see immediately what they are, and that will speed up matters considerably. Be prepared to send individual documents by email during the hearing. Certainly it is inevitable that there may be one or two documents that haven't reached a court file, or one or two documents that the court considers it necessary to see for that particular hearing. If these documents are easily and readily available on the computer that you're using when conducting the hearing, or they've been provided to whatever advocate you decided to instruct for that hearing, and they can be sent individually, very often a suggestion can be made to the court that can be sent immediately to a particular judge's e-judiciary account. If that's the case, you don't want the situation whereby the documents themselves are part and parcel of one PDF with perhaps sensitive or confidential information. And so if they can be in individual forms, they can be sent off easily, and that can speed up and indeed allow a hearing to continue. For example, I've had it where the present R in a CCMC hasn't been available, but that was immediately able to be emailed to the court, and that allowed the hearing to progress. Again, an obvious point, but sometimes there are problems emerging when one party sends in a bundle without agreeing it with the other party, and therefore the other party feels they have to send in further documents to the court. And then you have two competing bundles, which causes delay, causes confusion, and may lead a judge to consider that he has insufficient time to deal with that application. So agreement and cooperation is paramount there. Trials, if you're lucky enough to get through the interlocutory matters, you've made the applications, you've had CCMCs and the courts actually listed, or the potential for a virtual trial, and that's a fantastic situation. However, of course, we can assist the courts in identifying at an early stage what cases will be suitable for remote hearings. And if you can identify at an early stage if the case you are dealing with is one that can be heard, then of course the court can be informed and arguments can be raised at an early stage. However, realistically, consider, are there reasons why the judge will physically need to see a witness, have to have a witness in court rather than on the end of a video camera? Issues such as fundamental dishonesty, allegations of fraud, judges are more reluctant to make these findings following a remote Skype hearing than an open court, and the reason's clear. Very often it will necessitate an assessment of an individual, how they hold themselves up in court, the manner in which they answer questions, are they evasive, etc. Doing this by video is much more difficult. But of course, an important consideration to make as well is that justice has to be seen to be done. If an individual is going to be found fundamentally dishonest and potentially face contempt proceedings, which could potentially lead to imprisonment, that individual will want to know that there's a fair hearing in the first place. And a finding of fundamental dishonesty by video is very different to a finding of fundamental dishonesty in open court. Are there logistical reasons why there has to be physical presence in court? Are there going to have to be translators? Now, there have been hearings where translators attend either by video, but the reality is, I think, that they are more difficult having translators at a hearing when they're not physically present or close, 2 meters or so, from the person given evidence. And of course, if there are difficulties in the video quality and in hearing it, then the translator's role is more difficult and it takes that much longer. So translators do not necessarily equate to an easy video hearing. Are there particular exhibits which will be in court, which physically have to be there or looked at? Is there going to be video evidence which the court is going to have to look at? It's one thing providing perhaps a video file to the judge to see, but there's a completely different matter playing that video extract to a witness and cross-examine them on that. There are facilities where you can share videos online. I'm not quite certain if the court will have that facility or individual advocates will have that facility. And so that's one consideration as to whether or not a trial remotely is realistic. Are the client's witnesses able to participate remotely? Don't make assumptions that your clients or witnesses have laptops or computers at home. Don't assume that they're living somewhere with sufficient bandwidth or even a room they can retire to. They might have, for example, have significant childcare issues. They may not have a room where their children or other family members can sit in, or somewhere quiet where they can give evidence. All these matters can be identified at an early stage. Considerations of whether they can be overcome. For example, I'm not sure how feasible with government guidelines, but would it be possible, for example, in conference rooms, in offices, to be used for individual witnesses to give their evidence if they don't have the facilities at home. That will depend upon government guidance on movement, but certainly that seems one possible option. Can family members be approached if there's going to be increased allowance of meetings of individuals or family members at home? Can arrangements be made to look after children, for example, when evidence is going to be given? The sooner the possibility of that is determined, the sooner submissions to the court can be made as to whether a remote trial is possible or practical. If full trials cannot be heard remotely, can there be a preliminary issue hearing? For example, if a liability hearing where fundamental dishonesty may not be relevant to liability, but highly relevant to quantum, can there be a split trial on liability with a matter of quantum be determined at a later stage? That is one approach one member of Chambers had last week in a matter where there was decided to have a split trial to allow it, and it went ahead remotely as well. Other practical considerations, if you're going to be conducting a video trial by Skype, to consider about, will the witnesses be able to see a bundle of documents during the trial? Because of course, looking at my monitor now, as many of you will be doing, you're looking at the video, you might have the facilities to have multiple documents open at once. The only trouble with that, of course, is it's very different for a lay witness to make use of that facilities if they're not used to it, but also their laptop might be too small. They might have technical difficulties in looking at a bundle of documents on their computer screen as well as using the video facilities. Do they have access to a separate screen to view it on? Or can a hard copy be provided to them? Clearly, if a hard copy can be provided to them, you make sure that they have it, then that will solve a lot of the difficulties. Can there be familiarity training for witnesses before the trial? This isn't a case of coaching a witness to see evidence they're given, but there seems no reason in principle why they cannot be familiarized before they give evidence, a matter of days beforehand, as to how these particular hearings will work and advice in relation to that. All these matters allow a video trial to run not seamlessly, but certainly to try and avoid many of the delays and problems that can occur. Never practical considerations. How will you communicate with counsel or your client during the hearing itself? Because clearly, whilst you're all being videoed, you can mute, obviously, the aspect of it, but to communicate with your legal team or your client during the hearing have to be practical considerations as well. The first video hearing I had, it was a WhatsApp. A message had been sent, permission had been granted by the court to do so, but that worked quite well. But these are matters to be considered and practiced before any virtual hearing can take place to ensure that there aren't delays or unnecessary adjournments during the hearing itself. Finally, advice from one of our silks in Chambers in relation to how to perhaps get the attention of the judge when you're having difficulties contacting the court. Certainly ringing up the court is difficult. They're much more short-staffed, and very often you won't get an answer. The suggestion being, if you want the court to approve a proposal for hearing to go ahead remotely, then send an email marked urgent for the attention of the judge, set out the case details, proposals within that, clearly set out, and that way it has a realistic chance of getting to a judge and being given proper consideration. So those are my practical tips on having to avoid the dreaded adjournment of matters and trying to make these hearings progress a little bit more smoothly and to persuade a judge not to adjourn matters. And I know certainly members of Chambers have had the misfortune of matters being adjourned despite getting on the telephone and being in front of a judge. The more we can do to assist the court, the less likely that's going to happen. Over to you, James.
Thank you, Hugh. Hopefully you can hear me, Hugh. I'll just double check. Good. I'll just pop up a presentation, some slides. There we are. my part of the talk, conducting joint settlement meetings remotely. Joint settlement meetings have been in people's diaries for, of course, a little while, and there's no need necessarily to adjourn those. And with the prospect of trials being adjourned, one of the best ways actually to create a bit of certainty in a case is to get it settled if at all possible. So I over the lockdown period I think I've had 3 joint settlement meetings that were in the diary already, and we've managed to conduct those and achieved successful negotiations in all of them. So how do we go about that? I canvassed people in chambers for their top tips and hints. One hint I got back was this. Now, probably not particularly advisable. One can see why, because interruptions can be pretty difficult to deal with. Especially, particularly inadvisable for me, given my surname. I once got mistakenly entered into a hotel booking as Fritzl. And to be called Fritzl and giving advice about locking up children really isn't something that one ought to be doing, frankly, at the best of times. How then do we deal with it nice and efficiently? Well, point number 1, be well prepared, which of course we would be anyway, but do it well in advance. These are the 3 key tips so far as I'm concerned. Convene well before the day of the JSM with your solicitor and client. My experience is almost exclusively with defendant insurers, but I think that must apply so far as claimants are concerned as well. And the reasons for that are, I think, really twofold. The first is we are deprived of the opportunity that we usually have at the beginning of a JSM to sit together for an hour or so in a room and discuss tactics, strategy, and so on. To leave that sort of discussion to the day of a putative JSM with the sorts of problems that there can be with technology, glitches with phones, people's availability during the day because of other commitments, really is asking for trouble. So make sure that you convene a meeting. The day before is fine, but please not on the day itself. When you have that meeting, you should, again, absolutely key is to conduct that meeting using the same platform that you're going to be using to stay in contact during the day of the JSM. Whether that's a telephone conference facility, or if you do want to use video conferencing, a Zoom meeting or something of that sort, use exactly the platform and contact details that you will be using on the day itself. Practical experience of that, I had a JSM where we had a conference call set up on the day of the hearing, unfortunately, on the day of the JSM, unfortunately, and it was set up by the solicitors and it had been done by the IT department. Now, the problem was that one could join the telephone meeting early without any problem, but as soon as one rang off, that meeting was finished and it was impossible to actually access that meeting again. Now, setting up lots of multiple meetings during a day is impossible. Fortunately, in our case, because of the facility we have in chambers to use I think it's called 3CX platform, we were able to set that up, phone in throughout the day into that, and convene throughout the day to catch up. So that, as I say, is a very important factor to use. One can also, and again, this is important, agree a rough timetable for what you will do during the joint settlement meeting. Transpose, if you will, how you would deal with a JSM if one were meeting in chambers, but in a remote setting. So what we need to be able to do is have the opportunity to discuss with opposing counsel what our positions are and what our offers are. That's easily done by way of direct telephone contact by and large, but set a time for when that first contact will be made. And having had your meeting beforehand, you'll know exactly what your position is and what any opening gambit might be. But also agree that you will reconvene throughout the day, and that if you haven't, for example, been in contact within an hour, that you will send an email simply to keep people appraised of what's going on. That's especially important for your own side, but also as a matter of courtesy, if an offer's been made to you and it's taking a bit of time to reconvene, do drop a line to your opposing number to let them know what's happening, just so that the wheels run smoothly. I don't think one needs to be too prescriptive about the timetable because people will have different commitments, they'll have a different ability to contact you throughout the day. I know some chambers have come up with the idea of a protocol where if you don't get back in touch within a certain time, the other side can be entitled virtually to pack up their bags and leave. I'm not sure that's a sensible approach, frankly. I don't think one size fits all. And far better, in my view, to have a relatively flexible approach throughout the day, provided everyone has a rough idea of the shape of things. Another very important factor to bear in mind is the preparation and sharing of documents beforehand. Now, this is especially important for the meeting that you have with your client, insurer, or perhaps an injured claimant, so that you're all working off the same song sheet. If you're not in a room together, being able to share hard copies of advices and so on, it's extremely important to ensure that you are working off the same document. And this echoes the points that Hugh's already made about best practice in a court hearing. My practice, and I think probably best practice for this, is to create some sort of valuation table. And that will work even in relatively complex multi-track claims. That should work. And here's an example. I've changed this is from a case I dealt with recently. I've changed the numbers and so on and some of the comments. But this sort of document serves as this is only the very first page of about 8 or 9. This is incredibly useful to act as a comparative document. We all know what page we're on. We all know what line we're on. We all know what's being said by claimant and defendant. And we can sort out best offer and so on and so forth. And we can have little bullet point notes and comments about matters. Now, it may be in a more complicated case where there are difficult issues to do with care, aids and equipment, so on and so forth, that you might want to share this type of document with your opponent as one works through the negotiation. Now, if you're going to do that, you really don't want to be sharing the document I've just put up on the screen, talking about how appalling your surveillance evidence is, for example, and comments about, well, counterpoint that our opponents don't seem to know what they're doing. Perfectly fine, I'm sure, to say that in conference and in this sort of document, but if we are going to share, do make sure that it's suitably redacted. Which leads us on to this question, really, to see or not to see, and this is true of the platform that you use for your meetings before the JSM. For the JSM itself, do you want a video platform or an audio platform only? And also the question of sharing documents. Now, if you're going to share documents, I have to say I found Zoom very useful for doing that in the context of conferences with experts, where I can get their report up on the screen that I've suitably annotated, and we can run through it on screen together. In fact, in lots of ways, that works almost better than being in person with them, because you're all looking at the same screen and running through it at the same time. When it comes, though, to discussions with your opposite number, I really don't particularly see the need for a video platform personally. Sometimes some of the offers and points I have to make are probably best done when no one can see my face, frankly. So doing it over the phone makes life a bit easier. And I think it is probably true generally that you're more likely to get glitches with a video type platform than you are just speaking over the phone. So perhaps more sensible, I would suggest using audio only for JSMs, unless you do want to share a document. Another crucial factor is client availability on the day itself. And I think this falls into two categories, really. The client must be available all day. Now, whether that's the insurer client or the claimant, for reasons that Hugh's already touched on, which is that general experience has shown that dealing with matters remotely just takes more time. And that's especially true with a JSM, because if you compare and contrast what would have happened if we were all in Farrar's building together, we would have a discussion, I would meet with my opposite number, I'd come back through the door and I'd tell you what had happened, and you might have heard some of it anyway. But that's not the case with, obviously with it remotely. One has to report back, one has to reconvene, one has to have discussions and then go back again. So that does draw out the process. And when one adds into that the complications of perhaps people's childcare commitments and so on and so forth, one can well see that a full day needs to be set aside. Of course, the great advantage, and actually this is I think possibly a reason why remote JSMs might continue even after restrictions have been lifted, is that it's an awful lot easier to get us all in one place remotely, even when there are other commitments going on. I certainly know from having spoken to insurer clients that setting aside a whole day to go to chambers can often be quite difficult for them in terms of other workload. Whereas if they're not having to be stuck in a room, having to listen to my drivel for the whole day, they can be at home at their desk or in the office perhaps in the future. And the JSM actually takes up a minimal amount of time, and they're not constrained by travel arrangements and so on. So although it's a requirement of an availability all day, there's actually quite a decent upside to that. The other point is that one has to be easily and quickly contactable. I think this especially goes for claimants who may well be at work, for example, or have childcare commitments. You have to be able to take those instructions sensibly and quickly, otherwise the momentum of the JSM may well disappear. So those are my key tips really for how one runs a joint settlement meeting remotely. In lots of ways, it's not that different from doing it physically in person, but extra care in preparation. Certainly from counsel's point of view, extra care in providing a very detailed note of your conversations with your opposite number, because we don't have that benefit of popping back into the room immediately and having the discussion with your solicitor and your insurer. So those are those top tips there. So far as I'll touch on something different, which are pre-trial settlement hearings. These probably be known to any of you who handle any sort of multi-track work at all. They're very much the product of the South Coast. I think His Honour Judge Simkis, I suspect they were his idea. He's extremely keen on them. So if you have any sort of multi-track work in the south of England, and I think they're also used around in Bristol and so on, and I think they're expanding really in use. They are They are not a pre-trial review, although one can deal with pre-trial review matters there. They are there specifically to get the parties at court in order to discuss whether this claim can be negotiated and settled. And they are especially concentrated at the moment because now is the time in Brighton, Canterbury, so on and so forth, that we're approaching what's known as multi-track fortnight, which happens a few times a year when all multi-track trials are listed. And the pre-trial settlement hearings will come at a safe distance ahead of those. And at the moment, just to give you a bit of an update on what's happening in the multi-track cases on the South Coast, I had an application hearing in front of His Honour Judge Simkis yesterday. I spent the afternoon peering into Judge Simkis's, as he described it, drawing room, and spent quite a bit of time looking at his head as he peered very closely into the computer monitor. And his view is that at the moment, the multi-track trials that I would have been conducting will almost certainly be adjourned off, not to be heard before the autumn, he didn't think. We had a bit of a general discussion. And the reason for that is that in the case that I was dealing with, there's some quite complicated evidence about business profits and so on, and a need really to cross-examine the claimant over quite a long period of time, I suspect, about those issues. He didn't sound particularly optimistic about many multi-track trials going ahead remotely. However, we do have a pre-trial settlement hearing happening in about 3 weeks or so. And I asked how that would operate, because usually what would happen is about 8 cases would be heard by a single judge on the same day. We'd all turn up ready for a 10:30 start, and Judge Simkis or whichever other circuit judge was looking after that particular list would call you in turn and give you the benefit of their wisdom and experience about the case. Now, that can't work remotely, but apparently what is happening is they are listing 2 pre-trial settlement hearings on the same day. They'll list one at 10 o'clock, they'll list one at 10:30, and then they'll juggle them throughout the day, providing the parties opportunities to discuss between themselves offers and so on and so forth. I'll provide an update perhaps on that when it actually happens and how effective that is. But it seems as though they'll essentially take the form of a JSM in the way that I've described, but you will have to appear via Zoom, I think, or rather Skype for Business, I should say, at Brighton County Court or in Judge Simkis's drawing room, and deal with it in that way. So that's where we are with that as a sort of practical consideration. Now, Hugh's quite jealous, I think, of my collection of weekly law reports, which I actually was very kindly given to me by a former member of Chambers, and they do look very impressive. I have read some of them at points, but you really do need to be careful about judging people by their bookcases, I think, because inside the front cover of those volumes is this. So this is a plate which sets out that this comes from the ex libris, so from the library of Miles Henry Jackson Lipkin, and there's a very impressive coat of arms there. So a terrific collection of weekly law reports with a very impressive plate that's been printed on the inside cover of each of them. But the judge from Chambers who kindly gave these to me said he bought them secondhand from Wildey's, and he got a bit suspicious about this coat of arms, and he did some investigation, and it turns out it's completely fraudulent and false. It doesn't exist. Jackson Lipkin has no coat of arms at all. He's just made this up entirely. And it also turns out, you can look this up yourselves, but Jackson Lipkin himself he ended up as a QC in Hong Kong. Hugh may know him, in fact, I don't know, but he spent part of his life out there. But Jackson Lipkin, it turns out, lied about his naval service. He lied about the rank that he'd achieved when he left the Navy. We see he's fabricated this coat of arms, and he also was found guilty of benefit fraud in Hong Kong and became one of the first judges ever to be imprisoned. So as impressive as it might all look on the outside, the truth is that it's utterly fraudulent on the inside. I'm not quite sure what that means about our bookcases, but there we are. And then we can see Hugh switching as we speak. So that's my presentation. I'll just try and exit this without crashing everything. And I shall stop my sharing. Hopefully I've reappeared. I don't know if there were any questions.
No, there's we have the facility, those watching, and there are still a few still participating. There's Q&A and questions can be asked, but we do have one by email. I'm going to be like Jeremy Corbyn here. This comes from Julie. Would the Prime Minister please give his view on how, during a judicial mediation conducted by a telephone video, how will the legal representative liaise with their client in private? Any views, James?
I suspect that it's going to have to be by WhatsApp, isn't it? I think the way that you operated it in the, I think it was an employment tribunal hearing, wasn't it? I suspect that's really the only way, realistically, we can deal with it remotely.
Yeah, I think with something like judicial mediation or the hearings down in Brighton, or where there is some degree of judicial mediation, of course, when the judge is talking to the parties, that might be mediating, might be the judge, then the client and yourself won't be discussing matters in front of a judge in any event. And I think what practically happens is the judge or the mediator will retire. You are then, I think, have your own facilities, your own chat room, whether it's by Zoom or WhatsApp. You can do WhatsApp video itself, but something separate. I mean, my advice would be to make sure it is distinct from the system that you're using for the mediation or the JSM, because there's just too much possibility and scope for a dreadful mistake to be made. So a separate system, but you should be allowed an opportunity to retire, and by retiring, by muting, or you agree to log in at a certain time to come back before the judge. I think that's probably the practical way of doing it, but I haven't yet done a judicial mediation.
I think there's probably a leading on from that, it probably factors into remote trials. And if we think what happens in a courtroom when you're cross-examining somebody, or how everyone's asking questions, in fact, quite often there'll be a tug on your gown, or a note will get handed up. And that sort of, that immediate interaction is going to be very difficult, isn't it? So I suspect that WhatsApp's a bit of a clunky way to deal with it, but that might be the answer. But as you say, I say WhatsApp because it has to be separate and distinct. You don't want a client, butting in and stuff, making the point, which is, because it all has to be recorded. There are no sort of noises off when any of you are connected to a Zoom call, or Skype for Business.
Yes, so I think that is probably all the questions. We have had a new question. I know 2 new questions here. We have from a Narinda. How will you be able to show a judge a go-kart in a remote trial? That relates to a possible trial involving a go-kart. I think the simple answer is, if we're insisting on the judge viewing a go-kart, it's not going to be a remote trial, but we'll discuss that later.
I think I did a case about a go-kart once as well. They're obviously dangerous things, aren't they?
How do we stand, this is from Jenny, how do we stand on witnesses who are furloughed at the time of a hearing and are giving evidence on behalf of the employer? Furlough rules state that there cannot be any work conducted on behalf of the employer or it breaches furlough rules, I assume this is a genuine reason to seek adjournment.
Yeah, if you witness summons them to attend, that I don't see that they're actually working on behalf of their employer when they intend court to give evidence at trial. That they're attending court to give evidence, virtual or remote court, whatever it might be, or even if it does become in person, then I don't think that one can say that they're actually there by way of the requirement of the employer. They're there because they've been witness summons. It falls outside the scope of their contract of employment, I think.
Right. Well, I think particularly difficult question. I know that was a matter which a member of Chambers had to deal with. There was, interestingly, a webinar by a member of the judiciary last week where the issue arose, and there wasn't given any particular indication of what way the judiciary would have gone on. It's clearly, it's always going to be at the discretion of the court as to whether or not a hearing goes ahead. And so really it will be what the judge takes the view of furlough. Of course, furlough can be lifted and reinstated. And I suppose that's a possibility as well. There can be someone can be made as effectively come back to work and they can be furloughed again. So that might be an answer if you were opposing the adjournment. One more question, it seems. No, that relates to the furlough issue as well. It's, yeah. To be honest, it's a good point. Furlough's got lots of problems with it. Are they working? Will you have to lift a furlough if an employer contacts them in relation to that? Will there be contact by the HMRC at a later date?
Well, I suppose one answer might be try and get adjourned off till after October when the furlough scheme might end, from what I can work out. But there we go.
Yes, but those are matters, they can be raised to the court, and if the court still goes ahead, then it seems certainly the employer may well have a good argument if HMRC makes life difficult for them, but they had no choice.
Yeah.
So, yes, and as someone's contributed that furlough staff can't undertake income generating work, so probably okay to give evidence in court.
I agree, Alice. I think that's right.
Right. Well, listen, I'm sorry there's no quiz questions. Those courts, if anyone's remotely interested, not that, I don't know how many of you actually go, because probably most of you listening enjoy sending us to these courts rather than attend yourselves. Just let me share it for you finally. Share my screen. That.
I think, is that Brentford?
No, it's not Brentford. It's Dudley. And there's actually a sign in the car park to stop curb crawling. That's why Dudley is in my mind. The next one, anyone know? That's my favourite court in the United Kingdom. That's Mould County Court, which is generally in the middle of Mould and not what else. And finally.
Oh, is that Walsall? That
is Walsall, the only court in the land where you can have a hearing and then go to the pub immediately afterwards and get a kebab down below. Right, there are no more questions, are there? Have we frightened anyone else off? James?
Not as many as we thought.
No. Okay, well, listen, thank you all very much for tuning in. No other pub questions there. No one's won the prize, but thanks very much for your interest. We hope that's of some help and assistance. Certainly from the bar's point of view, we're very grateful if cases aren't adjourned and you don't necessarily agree everything and that we are sent to court on your behalf. And on that plea, thank you very much and keep safe.
Thank you.